And I'm going to share my screen right now, put up the slideshow. It's got everything on there. Hopefully you guys can see that. It's a little strange because I can't see or hear anything on my end. So this is the new laws slideshow. We're going to go through this very quickly today, and we'll go over the legislative history, what's taken place over the last year. We'll go through all the new laws, not all of them. In fact, we'll go through only a handful of them. Basically, we'll talk about the new laws that went into effect, including AB 3088. And because I know everybody really wants to talk about AB 3088, a lot of the other slides I'm going to move through very quickly, especially if there's slides that are less relevant. I included only the laws that were relevant to landlords. So, for example, Prop 19, which deals with inheritance of single-family homes and the jump up in basis on that, I did not include in the slideshow. Like I said, because I know everybody really wants to get to the most recent update on AB 3088 and talk about that and how that's going to affect them, I'm going to go through a lot of this stuff very quickly. I'm on a very limited time frame today. So first, we're going to go over the legislator overview. It'll tell you what took place up in Sacramento, how many people are holding what seats. Then we're going to go through the legislative overview, and we'll take a look at that as well. Then we're going to go through the 2021 compliance reminders. Now, I usually put that at the end. I'm going to put that up front today, again, because I know that everybody wants to get to AB 3088, and I know that that's really probably the hottest topic that people want to know about. So we'll go through the new and amended laws for 2021. First, we'll take the federal level topics. That'll include the CARES Act and the CDC eviction moratorium. And then we'll go through the state level topics. And the topics are broken into about 6 or 7 categories right there. And each category will have 2 or more new laws in it. So we'll start off with the homelessness and homeless shelters. That's a big topic. It didn't get a lot of attention this year, mainly due to COVID. Then we'll go into development and administrative and labor issues. We'll talk about regulatory. There's quite a few regulatory laws that took place this year. And then we'll go through environmental and green energy. And then we'll talk about 2 laws in particular about terminating the tenancy. And one of those, obviously, is AB 3088. So let's jump right in. This is the election results. This is the legislator overview. This is up in the Senate. We had 30 Democrats get voted in, so they gained 2 seats, and there were 9 Republicans. That was a loss of 2 seats, and we still have 1 vacant. There was no change in that. On the Assembly, the Democrats maintained a supermajority, but they lost 3 seats. There's 60 Democrats now, loss of 1 seat, and then 19 Republicans. They gained 2 seats, and then 1 independent, which was no change, and 1 vacant. So there's a gain of 1 vacant seat. Now, Governor Newsom is under attack, and there's a recall effort that's gaining steam. But I have my doubts that the recall effort's going to get very far. I'll give you some statistics and facts to explain why I say that. This recall was launched back in June of 2020, and the supporters have until March 17th of 2021 to collect approximately 1.5 million signatures for the recall. So far, there have been 5 recall petitions against Newsom, and each one of those has failed to qualify. So that's fact 1 that leads me to believe that this may not go anywhere. And of course, the rationale behind recalling Newsom, there's plenty of rationales for it. He's got an overreaching response to COVID. He's got never-ending taxes, incredibly high rate of homelessness going on right now. The state's position on sanctuary cities and the state's position on being a sanctuary state. His suspension of the death penalty, his decision to reserve water use, or ration water use rather, his unprecedented restrictions on parental rights, all of those add up. If you're on Facebook, there's actually a group called Recall Newsom, or Take Back California, it may be called. But anyway, you'll see that the numbers are growing all the time. Last June, when Newsom first discovered that there was a growing movement against him, he came out in public and indicated that the recall effort would cost the Californians $81 million in taxes. And he blamed the recall effort all on the Trump supporters. The big question, whether any of that's true or not, is irrelevant. $81 million in taxes to recall him may actually be cheaper than having him in place. But the big question, of course, is Is the recall movement going to succeed? And again, I have my doubts, and here's why. Here's some statistics. Newsom was actually elected with 62% of the vote. That is a huge percentage of the vote. Since 1911, there have been 55 attempts to recall governors. Now, think about that for a second. In 1911, we're basically 110 years in. In 110 years, we've had 55 recall efforts. That's a recall effort every 2 years. And out of all of those, the only successful recall effort ever launched was in 2003 against Governor Gray Davis. So whether Newsom will be recalled or not, it's up in the air. I have my doubts, but that's the makeup of Sacramento right now, how it stands currently. All right, let's take a look at the legislative overview. In the 2019 and 2020 session, we had almost 5,000 bills introduced. That's actually quite a bit lower than the session before that. 2019 saw 2,625 bills. 2020 saw 2,223, a 400 bill drop. And my suspicion is that you had 400 fewer bills in large part due to COVID. Approximately 210 of those bills affect rental housing in some way or another, but only approximately 20 directly impact the landlords. So let's face it, today there's really only one that we really care about for our purposes today, and that's AB 3088. So like I said before, we are going to discuss that, but I put it at the end of the slideshow because quite literally, even this morning before the slideshow, I was still sitting here working my way through the amendment. And it's changing daily. They are supposed to vote on it. They have a vote scheduled for today. It may not take place today. It may take place tomorrow. But either way, we'll know more by the end of the day tomorrow. So let's just jump right into the bills. These are the compliance reminders. So first of all, we've got SB 721, the balcony inspections. All buildings with 2 or more units have to comply with this. They must have an inspection of the elevated exterior elements, meaning wood structures above 6 feet extending outside the 4 walls of the building. That's going to include balconies, walkways, decks, porches, stairways, etc. They have to be inspected by a licensed contractor, structural engineer, an architect, or a building inspector with at least 5 years of experience. But you have until January 1st of 2025 to comply. So you've got 4 more years to get it done. But until that date passes, I'm going to keep reminding you guys every chance I get. And then you have to have subsequent inspections every 6 years. Now, the owner is authorized to enter the dwelling to comply with this requirement. And the reason I brought that up, you would think that that would be a given. But especially during COVID, I've had a lot of clients call me indicating that they're having a lot of problems getting in the units to do maintenance and repairs or inspections or things like this. So you are still allowed under the laws to enter the units to engage in any sort of maintenance and repair, including inspections. If you are having a problem with that, don't hesitate to call us. There are things that can be done about that. In fact, depending on the county or the local moratorium that you're dealing with, you can, and depending on your lease, I should add, you can actually file an eviction in most circumstances if the tenant is refusing to allow you to access the property to make these repairs. So like I said, if that's the problem you're running into, your tenants aren't allowing you in to make repairs or do whatever it is you need to do, don't hesitate to call us. In case there are those of you out there that don't know, Brennan Law Firm is a landlord-tenant firm. We represent landlords exclusively, and the vast majority of what we do is evictions. I'm heavily involved in the legislative component of things, but the firm itself does nothing but evictions of tenants. So if you need us, if you need our services, please don't hesitate to call. It's area code 626-294-0500. Again, that's 626-294-0500. We can help you through any of the situations you're facing right now, including some of these moratorium questions that are popping up. All right, the penal code, 396 is the penal code section. Price gouging. Essentially what that says is when we exist in a state of emergency, nobody can increase their prices on anything, goods or services, more than 10%. That was extended through an executive order, but that executive order expires March 4th of 2021. So we have a couple more months on that. Actually, we have about 5 more weeks on that. I would not be surprised. I'm unaware of it being extended as of today beyond that, but I would not be surprised if another executive order comes out extending that through at least through June, probably through the end of the year. So those are your two compliance reminders. Now let's talk about the new and amended laws for 2021. On the federal level, we have the CARES Act. The CARES Act has essentially expired several months ago, but there are a couple factors I want to talk about that. We'll talk about the CDC eviction moratorium. And then on the state level, like I said, those are the same categories I addressed before: homelessness, development, administrative, so we don't need to go through them again. Let's just keep going so we have more time for AB 3088. All right, the CARES Act, it did expire in July of 2020. There are a few lingering components for properties that are governed by Fannie Mae, Freddie Mac. I always get those two mixed up. But for our purpose today, those apply to very, very few buildings today. And I'm not going to take the time to go through the CARES Act. We do have the CDC eviction moratorium that still exists. In fact, it was recently extended. That was extended through March 31st of 2021. It applies to individuals earning less than $99,000 and couples less than $198,000. The affirmative obligation on the part of the tenant is they have to present the landlord with a declaration. Now, there's no obligation on the part of the landlord to provide the tenant with that declaration, as there is, for example, under AB 3088. When the landlord serves a notice, the landlord actually has to give the tenant the declaration. In the months since the CDC order came out, I have seen approximately 5 or 6 tenants turn these declarations in. Most of the tenants are unaware of this. On top of that, there is a debate going on in California whether the CDC eviction moratorium even applies, even though it's been extended. On the day it came out, Gavin Newsom held a press conference in which he declared that the CDC moratorium does not apply because the state's laws, according to the governor, are more strict than the CDC's laws, or the CDC's protections, I should say. The challenge is the CDC order itself states that they are leaving it up to the local municipalities and judges to determine whether it applies. And in Southern California, specifically in LA County, we've had judges come out on both sides of the fence. I've had judges say it does not apply. I've had judges say it does apply. I had one judge actually just this week say it doesn't apply up to the date of judgment, but once the judgment it kicks in, then the CDC order does apply because California does not address post-judgment evictions, even under COVID. So it's a hodgepodge, and your guess is as good as anybody's as to whether the CDC eviction moratorium still applies. I would say go ahead and file any eviction that you've got, if you're permitted to file it, and let the tenant come up with the declaration, and then let it go to the judge and let it be briefed and let the judge make the decision. What it technically says, it doesn't say you can't file the eviction. It actually just says that the tenant can't be locked out prior to March 31st of 2021. It says that the tenant, I don't want to try to quote it right here because I don't have it in front of me, but my interpretation is it simply says the tenant can't be locked out. So you could serve a 60-day notice right now, and that would expire after March 31st, for example, if you're in a jurisdiction that allows a 60-day notice. And so the CDC eviction moratorium wouldn't even come in. So I'm not going to spend any more time on it than that. If you have questions about whether it applies or not, feel free to call my office. We are moving into the state level now. So in the state level, we're talking about homelessness and homeless shelters. This is AB 1188. This one's, I don't know if this one really has any teeth or not, but it does authorize a tenant to temporarily allow someone who is at risk of homelessness to occupy their rental unit. However, and by the way, they get to occupy their rental unit. The way the law is written, it says regardless of whether the lease actually prohibits that. However, it does require the permission from the landlord in writing. So theoretically, there's no impact other than I would tell you that you would probably have to or want to have some good faith component to denying the tenant, but the landlord still has the right to say no as of today. So if the landlord does decide that, hey, this person's at risk, I'm going to allow them to occupy the property, the landlord would have the right to adjust the rent during that time. But I would encourage anybody who's even considering that. First of all, I would encourage you not to consider it. I would encourage you to just say, no, I'm not going to agree to that. Getting an individual out, especially during the pandemic, could prove to be very, very difficult. Additionally, if you were going to do it and you were going to adjust the rent, make sure you comply with both state and any local jurisdiction law that might be in place, local jurisdiction rent control law that may be in place. Make sure you look that up before you simply try to kick in a rent increase. The tenant would remain liable for the actions of the occupant, and the landlord has to provide 7 days notice prior to evicting the occupant. So if the occupant, for example, starts throwing parties in violation of any stay-at-home orders, the landlord would have to tell the named lessee, hey, I'm giving you 7 days notice that I'm going to file an eviction against this occupant of yours. But the tenant could cure the violation. And so again, essentially, this is almost like the state authorizing a subtenancy that currently requires the landlord's permission to do it. I would not encourage it. I do wonder to myself, how long will it be before they remove that requirement that the landlord actually agree to it in writing and simply make it illegal for a lease to say, hey, there's going to be no subletting or no assignment of this lease. It does seem that we're moving in that direction. All right, moving on. Still on homelessness and homeless shelters, AB 2553, emergency homeless shelters. This basically streamlines the permitting process for a city to construct a emergency homeless shelter. It provides local municipalities the flexibility to approve and expedite the construction of the shelters. This is based on a project that went into effect up in Oakland, Berkeley, and San Jose. It was claimed to be a success back in 2017. I guess that depends on your definition of success. I will give you some statistics, though, that are driving this. California has the highest rate of unsheltered homeless individuals in the nation. And if you believe these statistics, they're somewhat alarming. Actually, they're very alarming. It says on any given night, more than 150,000 Californians experience homelessness. Okay, I can believe that. But here's the ones that are somewhat mind-blowing. In Los Angeles County, for every 133 people that find housing, 150 fall into homelessness. So a gain of 17 people on top of the 133 that have housing. 150 do not have housing. That's a crazy number. It would almost imply that more than almost, what would that be? The 100 and something percent of those who are housed are also homeless. I find it difficult to believe that, but I'm not the statistician who took this. They state in Oakland, for every one person housed, 2 more become homeless. So again, assuming that these statistics are correct, these are crazy. In San Francisco, for every one person housed, 3 become homeless. So the point of these statistics is there is a significant homelessness awareness trend that's been going on for the last, I would say, 7 years up in Sacramento. And it is driving a lot of the policy concerns. In fact, it's behind AB 3088. A large reason that the state backed this COVID law the way they did was the fear that we were going to have so many more homeless people than we already have. So as I said at the beginning of the slideshow, I believe that the session was cut short as far as how many bills were introduced because of COVID and the fact that the session was actually put on hiatus twice during last year as a result of COVID outbreaks. I think you would have seen a heck of a lot more bills introduced, and I think that you're going to see homelessness as a main theme for the next decade, especially in light of the economic situation. I want to take an aside on that, actually, now that I think about that. I want to remind people that, I've been doing landlord-tenant law since prior to even being a licensed attorney, at least 15, 16, 17 years now. And prior to 2008, we started to see a bunch of laws get implemented that really made no sense. And we were asking ourselves, hey, why are these laws coming down the pike right now? And of course, 2008, 2009, 2010 hit, and the economy had what they call the Great Recession. And it's interesting because it seemed like the legislators really knew what was coming in advance and started crafting these laws to deal with it at that time. And the battle cry right now is that they didn't go far enough. And over the last several years, we've been seeing a whole plethora of these same type of laws that have been coming out that are really trying to deal with an uncertain economic future for us and what I think is a perception in Sacramento that we're going to have a mass amount of homelessness. And so that explains why a lot of these laws are coming out written the way they are. They're trying to keep people sheltered in place in light of what I believe and what I think Sacramento believes is going to be a very delicate, or actually a destroyed economy in a very short time. So keep that in mind, that you will see more homelessness and homeless shelter laws coming out of Sacramento. And I have a feeling they're going to be pushed and pushed and pushed and pushed through more than we're used to. All right, so moving on, let's talk about state level development. The only reason I'm talking about development is because as the densities throughout the state increase, and as as home affordability decreases, there is a greater need for multifamily housing. That may sound good to some people, but when you see some of the development laws that are coming out with the multifamily stuff, one in particular that I will talk about, it gets a little bit alarming or concerning as to what's going on. But anyway, SB 831 streamlined the multifamily project permitting, and it authorizes applications for multifamily housing development projects through a streamlined ministerial approval process. It's conditioned on the development satisfying specified planning standards, including the requirement that development be located on a site that satisfies localization, urbanization, and zoning requirements. So that's that one. That one's relatively benign. AB 725, another multifamily upzoning. Now, this one is the one that causes me alarm. It sounds okay when you first look at it. It allows multifamily development in single-family neighborhoods, up to 30 units of apartment housing per acre in metro counties. If you do that math in your head real quick, that's a lot. 30 units per acre. It doesn't sound like a ton, but it's bigger than you think in a single-family residence, or a single-family neighborhood, I should say. 20 units per acre in a suburban county, 15 units per acre in cities that are rural, and 10 in unincorporated areas. Now, there's been a lot of criticism on this law, specifically, it destroys single-family housing neighborhoods by it requiring cities to relocate at least 25% of the future required growth into fully established single-family, duplex, and small apartment neighborhoods statewide. And obviously, the fear is that that's going to destroy working class and middle class neighborhoods to speculation and buyouts. It's going to target single family and low density areas for construction. And the funny thing is, the AB 725 does not provide any funding whatsoever for any of the infrastructure that's going to be required to take care of these increased families. So for every one of those units, if you take just an average of 2.5 people or 2 cars per unit, that would be 60 new cars in that one building on 1 acre. And yet the state and this law did not take that into consideration whatsoever. Furthermore, about 75% of residential zoning in Los Angeles, San Jose, and many other cities across the country are single family. And in California, that is now talking about moving these multifamilies into those single family neighborhoods. So a little bit concerning on that one. I'm going to move on. I really want to get to the AB 3088 stuff. SB 1030, Housing Accountability Act. This gives a county or a city, or requires a county or a city to provide a list of surplus land to anybody upon request, whether they're an individual or an entity. Now, it used to be that you had to be a citizen to make that request, or to have the city or county required to actually give you the document. You had to be a citizen. That has changed now. You're no longer required to be a citizen to get that list. It permits owners of an ADU who receive a notice of violation or a notice to abate a nuisance condition to seek an extension of 5 years on that. Now, the extension won't go on forever. There are criteria to get that extension, but it does, as long as that violation is not a health and safety concern, you will have up to 5 years to correct that condition. All right, let's talk about this a little bit more in detail. I just want to look at my notes real quick and decide. So this law, I want to decide whether it's worth going into, or should we just keep moving on for AB 3088. It looks to me like the only 2 points I want to make on this are, the law does prohibit local agencies from disapproving a housing development project that complies with zoning, or disapproving of or conditioning the approval of a housing development for very low or moderate income households on an emergency homeless shelter in a manner that renders the project infeasible. So in essence, what the technical language is trying to say is that law prohibits cities and counties from either putting too many roadblocks in the way of development, or simply flat out denying a project where the project otherwise complies with zoning requirements. So again, you're seeing more development coming through in an effort to create more multi-family housing in light of the decreasing housing affordability and the increasing need for multifamily units. All right, AB 3308. Now that's not 3088, that's 3308. Another development project. This law, interestingly enough, permits school districts and developers to restrict occupancy to teachers and school district employees. Now, there's some limits on that. The school district has to own the property, and the housing can't violate any other applicable law. Well, right off the top of my head, I say to myself, well, doesn't that violate fair housing laws or anti-discrimination laws? But apparently it does not. It was decided up in Sacramento, it does not. But in essence, the rationale behind the law is that the average teacher today, an entry-level teacher, would have to spend 85% of their monthly income on rent based on current rent. It is actually factual to say that rents are extremely high in California, and that was the basis for passing this law. Again, they can restrict the housing to the teachers and to people who work for the school as long as they own the property and it's otherwise not. SB 778, now we've moved out of development and into administrative and labor. I just want to remind everybody the sexual harassment prevention training and education, that has already passed. The compliance date was January 1st, 2021. For those of you who have not complied, I would highly encourage you to comply with it right away. The original law that kicked this off came in 2018. That was SB 1343. 778 extended that compliance date, requires employers with 5 or more employees to provide sexual harassment training, 2 hours to supervisory employees, 1 hour to regular employees. It's got to be done every 2 years. You have to renew that training every 2 years. I will tell you that I forget the name. I think it's the Department of Fair Employment and Housing. Yes, they have a free online sexual harassment prevention training course that you can use. So that's what we did in the firm. We just used their firm. It's really actually quite easy. You sign up for it. They send you a link. You have to watch the video. The video is interactive, so you really do have to sit there and answer the questions every couple minutes. But it was very easy to get through it. Everybody in the office got through it on time, and it was nice how they set it up. So, like I said, use the Department of Fair Employment and Housing's free stuff. All right. Next one is AB 3254, document translations. Now, this expands an already existing law, Civil Code Section 1632. That required contracts that were negotiated primarily in another language, for example, Spanish. That required you to provide the other party to the contract a copy of the law translated where you're using an English language copy. So, for example, if you have a property that's in some part of LA that's heavily Hispanic, and your on-site manager, for example, negotiates that lease in Spanish and then provides a copy of the lease in English, 1632 would say, hey, you've got to provide a copy of that in Spanish as well. This law actually extends that right to receive a copy to guarantors and co-signers. So in other words, if you have an applicant, you negotiate it in Spanish, but you give them an English lease, and they have a co-signer, not only do you have to give them a Spanish copy now, you also have to give the co-signer a copy of it in Spanish and English as well. My recommendation is, if you're going to do that, I would encourage you guys to actually, there's an exception in 1632 that says when the applicant negotiates that contract or that lease using their own interpreter in English, then you don't have to provide the copy. So you might consider just having a policy that your on-site managers don't negotiate it in Spanish, they negotiate it in English, and that if a Spanish interpretation is going on, that the applicant or the tenant brings their own Spanish interpreter. Of course, you want them to be over 18 years old, and they possibly sign something that says, hey, yeah, we provided our own Spanish interpreter, and then you don't have to comply with 1632. There is a question. Let me just make sure I'm looking at the right thing here. I just want to I know I had a concern about this. The law actually states that the person who, if you do not provide a copy of that contract in that language, whatever it was, then the law says that the person aggrieved can actually get out of the obligation. What the law is not clear about is when you give a copy to the guarantor or to the cosigners, or rather, if you don't give a copy to the guarantors or the cosigners, are they the aggrieved person? In other words, if you negotiate it in Spanish with the tenant, but you fail to provide the tenant with a Spanish copy of the lease, even though the lease is in English, and you have a guarantor or a cosigner on there, and the tenant defaults in the rent, so you want to go after the guarantor now. Well, if you didn't provide the copy in Spanish, does the guarantor get to get out of the contract as well? The law does not address that issue, so that's unclear. So again, it may make more sense just to have a policy that negotiates all this stuff in English and has any sort of Spanish translation done through the tenant's own interpreter. All right, SB 3182. This adds on to the Davis-Sterling Act, which many of you know is a civil code section that deals with HOAs. It can be condominiums, co-ops, it doesn't matter. But this prevents an HOA from unreasonably restricting the leasing of an owner's unit. So associations under this law now may neither prevent the owner from leasing their unit, even in a PUD or a HOA or a co-op. They can no longer say the owner can't lease their unit, and they can no longer restrict the percentage of units that may be rented to less than 25%. Sometimes they said 10%, 5%, whatever it is. Now the baseline is 25% or more. Any ADUs or junior ADUs do not count towards that cap. So in other words, if you have 100 units and 10 of those units have ADUs on them, the 25% of 100 would be 25 units. The ADUs do not count in that percentage. So you'd actually get 25 plus 10 on the property. Now, the association is still permitted to limit the short-term rentals, for example, Airbnb, Flipkey, whatever platform you want to use. They are permitted to limit short-term rentals to 30 days or less. Actually, I said that wrong. They are permitted to limit leases that are less than 30 days. In other words, they can prohibit a lease that's less than 30 days and say a lease has to be 30 days or more. All right, let's see. AB 3366, expanded judicial powers. This one some of you might scratch your head and say, why is he telling us this? I'll explain it in a second. This modifies the existing law, which requires a superior court presiding judge to request the judicial council to order a case transferred to another court. Now, where would that happen, for example? Well, I'll give you a perfect real life example right now. With COVID and AB 3088 and all of these eviction trials that are being pushed off, or all of these small claims trials that are not even allowed to begin yet, the Los Angeles County Superior Court system is at some point going to get simply overwhelmed with all of these cases. In fact, AB 3088 alludes to that in the legislation. They actually specifically say we anticipate a huge number of cases. I can see it down the line where the Judicial Council says, okay, the Los Angeles County Superior Court system is overwhelmed. We're going to transfer certain cases to Orange County, or we're going to transfer them to San Bernardino County or Riverside County, where they have fewer cases. As the law sits right now, that would require the presiding judge of Superior Court to actually request the Judicial Council to do that. This law actually takes that requirement out of play and allows the Judicial Council to transfer cases to other counties or courthouses on their own without that request. So I'm telling you about this law, I'm giving you guys a heads up that I can see that happening when the floodgates open and all of this COVID-19 stuff starts to hit the courts. So be prepared for that. You may end up going to other counties to have your cases heard. All right, Prop 24, California Privacy Rights Act of 2020. This is another one that we already had a law in existence that went into effect in 2018. That was called the California Consumer Privacy Rights Act. This permits, it broadens the individual privacy and the data protection rights of individuals. It creates greater penalties and fines for data breaches. This does not apply to most landlords. There's minimum number of people that that have to be employed and handling individuals' sensitive data. So this is not going to apply to the small mom and pop landlord. However, depending on the size of the management company and certainly a screening company, this law will apply to them. Now it goes into effect January of 2022, but it's inoperative until January of 2023. So I really wouldn't worry about it unless you're, like I said, either a very large management company or a tenant screening company. But I did figure I'd bring it to your attention. It may cause the cost of screening to go up. All right, SB 1079. We are still in the regulatory. Like I said, there's more regulatory new laws than anything else. The residential foreclosure requirements are changing. This modifies the foreclosure auction process. The way this was put across, it was to keep the big bad Wall Street guys from coming in. So this is a perfect example of what I was talking about when I said, when you start seeing legislation like this go into effect, we know we're headed for a bumpy economy very soon. This modifies that foreclosure auction process to prohibit the bundling of foreclosed properties for sale. So what happened before, where companies like Blackstone would come in, and if you don't know who Blackstone is, you can look them up. I think they might be the country's largest rental company across the entire country. But anyway, it would prevent a company like that from coming in and buying these huge bundles of foreclosed properties, and it prohibits the purchase of more than 3 foreclosed properties per buyer. For those companies that want to do something like that, I imagine, based on the law, the way I read it, there's nothing to stop them from creating multiple entities to go ahead and do that and then consolidating those entities later. So while this is a feel-good bill that says to the average person, hey, we want the average person to go in and be able to buy a foreclosed property, if the big companies really want to go in and buy it in bundles like they did in the past, they'll still be able to do it. However, it does provide for a 20-day first right of purchase of a foreclosed property to owner occupants, tenants, local governments, and housing nonprofits. So in other words, if the property is foreclosed, before it can actually go to auction, there's a 20-day, let's call it a buyback period from those entities I just mentioned to you, the owners, tenants, local governments, and housing nonprofits. And this does authorize higher fines on owners that leave homes vacant or blighted. Again, going back to the 2008 through 2010 recession, what happened was a lot of these companies would come in and buy the properties and they sat vacant, and they went through what the city or county would call blight. Now, a lot of times those properties really weren't vacant. What happened was when they were foreclosed, getting the tenants out was problematic. And the tenant, obviously, since it's not their house anymore, or it never was, maybe they really were a tenant, but a prior owner is still in the property, they would just let the properties go to hell, for lack of a better phrase, and they wouldn't take care of anything. And the cities and counties are now trying to prevent that with the greater fines. All right, moving on. I want to make sure I covered everything on that. Did I skip a slide? Privacy Act, residential foreclosure requirements? No. Yes, I did. SB 1117, utility credits to tenants. This law basically prohibits landlords from charging tenants more for your utilities than the tenant would have paid if they went directly to the utility provider. The landlords are required to distribute to the tenants any rebates that they receive from the utility company as well. So basically, it's passing through any. The landlords are not permitted to profit on the utilities, and if they receive a rebate, it's got to go back to the tenants on a pro rata basis. I just want to make sure I didn't miss anything on that. I kind of get the feeling there was something else about it that I wanted to tell you. No, I didn't. All right, AB 3074, fire prevention. This increases the requirement to use greater fuel reduction practices. Essentially, it's anywhere between 5 and 30 feet around your building now will have greater fuel reduction practices. For example, there's going to be a ember resistance zone within 5 feet of the structure. Violations of this are criminal in nature. So it's a criminal penalty if you violate the law. Obviously, especially during the last wildfire season, we can see why a law like this would get pushed through. But even the criminal violations require the local agency to make reasonable efforts to work with you before they actually turn you into the city for prosecution. And the Department of Forestry is currently implementing a website that will provide you with greater details and information. One of the few laws, regulatory laws, that I say, okay, great, let's do it. let's figure out what we need to do. And you can do that by going to their website. All right, moving on. Environmental and green energy, AB 1551, PACE disclosure requirements. So this popped up. This is going on all across the country, at least in the sunny states. This popped up as a result of what were perceived as people in the solar panel industry taking advantage of the elderly when they would enter into these contracts that would finance the installation of the solar panels. So PACE obviously stands for Property Assessed Clean Energy. It enables homeowners to finance the energy and the water efficient home upgrades, such as solar panels, and it prohibits prepayment penalties in those contracts, and it prohibits assessments on properties with reverse mortgages. So again, they're trying to take special precaution to protect the elderly, who are really the vast majority of the people who actually take out a reverse mortgage are elderly. It requires the PACE finance estimate and disclosure to be in paper form, can't be in digital form, unless the individual signing the contract actually authorizes it to be in digital. And it contains a disclosure requirement for solar installers under the PACE program. So they've got to disclose certain things now. And again, that disclosure's got to be in paper. All right. AB 1788, the California Ecosystems Protection Act. This is one that, again, sounds fairly benign, but then you have to start thinking about it. What are you going to do as a landlord? This prohibits the second generation anticoagulant rodenticides. Now, what the heck is that? That is what your pest control companies have been using up until January 1st to kill rodents. The problem is that they were finding those pesticides or rodenticides in a lot of other animals that had that weren't rodents. They're finding them in all these animals, and those animals are becoming poisoned over time. And there was a study done, even when they started to diminish the amount of the SGARs, they still found that the animals around the areas where they were using them, their levels of the SGAR in their bloodstream were not going down. And so that's what created this law, is an attempt to save the animals that are not the rodents. So you can't use those anymore. So there are exceptions to what type of properties can use them. Unfortunately for apartment owners, the apartments are not in any of those exceptions. Essentially, agriculture, breweries, factories, medical facilities, drug and medical equipment facilities, those are all exempt from this law. Apartment buildings, though, are not exempt. So the problem is, if you can't use that to control rodents at your property anymore, what are you going to use? There are some methods, they're not as effective, but I would encourage you to discuss them with your pest control and develop a strategy right now, because, look at the bigger picture on this. Tenants, especially in LA right now, you cannot evict tenants who have unauthorized occupants. And I know, at least in my firm, we get multiple calls every single day about tenant moving in unauthorized occupants. We're looking at development of more multifamily all across the state. We have a high density region. Essentially, we're going to see an uptick in rodent problems in apartment buildings. And now we've just had one hand tied behind our back as far as being able to deal with them effectively. So like I said, start thinking about this and figuring out what you're going to need to do, because as we all know, habitability will come up in any sort of an eviction action that you're doing. And unless you have a procedure already mapped out, if the tenant is really experiencing a rodent problem, you're going to look up and say, well, my pest control company can't use pesticides anymore. And the court's going to say, that's your problem, figure it out. So I would encourage you to start developing a strategy for that now. All right. SB 1190. So we're now into the termination of tenancies. And this is the last law before we get to AB 3088. So SB 1190, basically this permits tenants to be released from a lease as a victim of crime. Most of this is domestic violence, but this law actually expands the provisions and authorizes a tenant to terminate their own tenancy without penalty. In other words, if they have 9 months left on the lease and they terminate their own tenancy, you are no longer permitted to go after them for that 9 months or any losses that you might incur. And you're no longer permitted to turn them in as being delinquent as a result of as a result of them terminating the lease, which resulted from domestic violence. Now, how does this law expand that? It allows them to terminate the lease where an immediate family member was a victim of the crime as well. it also expands the list of eligible crimes that can be put under that umbrella. Now, here's the problem. The family member does not have to live with the tenant, and the crime doesn't even have to occur within 1,000 feet of the unit for the tenant to be able to terminate their own tenancy. So the family member could live in a completely different building 20 miles away, and if they're a victim of domestic violence, your tenant now will have the right to terminate their own tenancy. So again, I'm not sure about what the rationale was for this. The only thing I could think of was the rationale was that, okay, my sister or my brother is the victim of sexual assault or attempted murder. I need to move in with them 20 miles away, and therefore I need to get out of my lease now. I did not read that in the law, but that's the only thought I had that might justify allowing the tenant out for a crime against a non-lessee that didn't even occur on the property. All right. This does prohibit a landlord or a landlord's agent, such as a management company, from keeping the tenant's security deposit or any advanced rent paid when the tenant exercises these rights. Now, what that does not say is that you cannot use the security deposit for unpaid rent. So if they terminate their tenancy, and as is often the case, they say, well, I'm using my security deposit as my last month's rent. You certainly could agree to that if you wanted to. I would tell you don't agree to that. Tell them they still owe you the rent. You're still permitted to use their security deposit in the normal way. You could use it for unpaid rent, damages beyond ordinary wear and tear, cleaning the property, and to replace missing personal property. But you can't simply say, okay, you've got 9 months left, so I'm going to use your security deposit, your 1 month security deposit, for one of those 9 months. That's what is prohibited. And it also prohibits the landlord from refusing to rent a residential unit to somebody who's otherwise qualified based on the fact that, for example, in your tenant screening, you did your due diligence and you called the last landlord, and the landlord said, hey, they terminated their tenancy in the middle of a lease based on a claim of domestic violence that I don't even believe, or whatever other crime that it could have occurred. If you found that out, you wouldn't be able to deny their tenancy based on that fact alone. You'd still want to go through the whole screening policy process and determine if there's another basis for denying the tenancy. And finally, the tenant who terminates shall not be considered to have breached the lease or the rental agreement. In other words, you can't sue them. You can't turn them into credit. Speaking of turning them into credit, it just dawned on me. I may have, I hope not, but I may have skipped a law, and I apologize if that's the fact. I will come back to it at a different time because, again, I want to go on to AB 3088. But there is also a law out there now that it permits tenants to request that a landlord actually start reporting their credit payments to one of the major credit reporting agencies. And the theory behind that is they did statistics, and of course it shows that tenants who are low income or moderate income, their credit suffers significantly. But if they make their payment of rent on time and that gets reported, that it has a significant impact on that tenant's credit rating, which gives them greater opportunities in life. It's kind of a double-edged sword for the tenant and the landlord, because the tenant actually has the right to put it in writing to the landlord that they don't want the landlord reporting those payments anymore. But as far as I can see, the only time a tenant would do that, especially do it in advance, would be if they believed that for some reason their rent payments were going to start being late sometime in the near future. So my guess is that most tenants who ask a landlord to start reporting are going to forget that they did so. And so that's the double-edged sword for the tenant. If you request it to be reported to the credit reporting agency and the landlord starts doing it and all of a sudden you fall behind, that is going to show up as a ding on your credit. Of course, the landlord is going to incur additional costs, but the landlord is permitted to charge the tenant up to $10 a month for those services. It's the lesser of the actual cost to report it, or $10 a month. But it's going to still be more administrative and procedural hoops the landlord's going to have to jump through. So again, I apologize. It looks like that slide did not make it in. If you're interested in knowing what that law is, please call my office after the slideshow, and I'll be happy to tell it to you. Let me give you the office number again. It's 626-294-0500, 626-294-0500. And again, I apologize. I either skipped it or I didn't see it. All right, let's move on to the most prominent question on everybody's mind right now. What is happening with AB 3088? Am I going to be able to evict tenants or go back to 3-day notices as of February 1st, like AB 3088 initially stated? And the answer to that is unequivocally no, you will not. AB 3088 is being extended. It's being voted on, actually, like I said earlier, either today or tomorrow. I anticipate it being done today, but some last minute wrangling and negotiation may take place, and so it may be voted on tomorrow. But it's beyond a question now. It's going to be extended, and we know it's being extended through at least June 30th, 2021. Now, before I go any further, I just wanted to say I was on a legislative call the other day, and everybody on the call had initially anticipated that it would be extended through December 31st of 2021. So in other words, another year. Now, there was a sister bill that was put out that only extended it through March. And so there was hope that we would get either March or June, like we did. But I want to manage everybody's expectations about this. You should know that come June and, I guess in June, this will very, very likely be extended again through the remainder of the year. The reason it's going through June is because June is the next session for the budget committee. In other words, the legislators in Sacramento will be going over budget bills again in June. So they put this through to June. It's a feel-good thing. It looks like, okay, we've only got 5 more months, but you can bet that when June comes, this will be extended again. And it'll be based on the budget again. Why do I say that? Because one of the reasons this is being extended is because, COVID numbers just spiked off the charts for a while. There are still claims that, a quarter of Californians are unemployed or have had reduced wages as a result of COVID. And the state had no money to help out. This is part of the reason the state uses for saying why they're not helping landlords right now, is because the state has a $50 billion with a B, a $50 billion deficit in its budget. And so the state is, I'm going to go through some of these terms right now, but you'll see the state is relying on the federal stimulus package for the vast majority of the funds that are required to administer this rental assistance program that they're going to start administering. And the assistance program is going to help both landlords and tenants. There's some caveats to that. We'll talk about that in a second. But this is all federal money. The only money, I could be wrong, but the only money I see coming into this is going to come through the state actually setting up the procedural component or the agencies that are going to be required to administer this. So we'll work our way through it. But anyway, the point is that the extension of the eviction is currently going to go through June 30th of 2021. It is going to require tenants to pay 25% of the rent. And while we negotiated very hard to get that 25% to be due every month, it didn't happen. The current bill that I was reading this morning still requires the tenants to pay the 25% either monthly or in one lump sum payment on or before June 30th. So that's unfortunate. Landlords are going to go another 5 months without a penny. Some of them will be lucky enough to receive a small amount, but the vast majority of tenants who aren't paying right now and who are using COVID as an excuse aren't paying anything. Luckily for landlords, the state preemption over local municipality moratoriums remains in place. Now, what does that mean exactly? Well, the original AB 3088 specifically said that no municipality could create, amend, modify, or change in any way any of their moratoriums, their COVID moratoriums that were in place as of August 19th. So unfortunately for people in Los Angeles, both Los Angeles and Los Angeles City, that really doesn't help them. Los Angeles City, by far, them, and I believe it was Santa Monica, may have had very similar language that said their moratorium does not expire until a certain time period after the state of emergency expires. So in LA, for example, the state of emergency will expire only after Mayor Garcetti says, hey, the state of emergency is over on this date. And the COVID moratorium will remain in place for 12 months after that. So even if Mayor Garcetti magically today said, hey, the state of emergency is over, the landlords in the city of LA would still be prohibited from even serving 99% of all notices for another 12 months. And the county of LA is completely disregarding the provision in AB 3088 that preempts their ability to extend their moratorium. The County of LA's moratorium, as of August 19th, expired for residential tenancies on September 30th. But the county has continued to extend it. And every time we talk to the county and say, I don't know how you can extend your moratorium, AB 3088 preempts that. Their position is that, no, it doesn't, and we're doing it anyway. So I just found out, or I just read this morning, the County of most of you already know, the city of LA is being sued. It's in federal court right now over their moratorium. I just read another lawsuit this morning that I had not known about until yesterday. In fact, the County of Los Angeles is now being sued in a recent lawsuit over their moratorium. I suspect that the county is going to be sued by multiple people over these extensions at some point. So we'll just have to play it by ear. I'm not going to give any legal advice over the internet right now about what you should do as far as the city or county and serving notices or not serving notices. I've put a newsletter out on whether you should serve notices or not in the city of Los Angeles. If you want to talk to me about the county or the city's moratorium, I'm happy to talk to you. Please call the office. I will tell you in advance, me specifically, but my whole office is incredibly overwhelmed with phone calls on an everyday basis. So please be patient. It is very difficult for me to call everybody back, prepare slideshows like this, work on my active cases, remain active in the legislative affairs, and do all the things I do in the industry, and still find time to call people back right away. So I'm happy to talk to you, but please be patient with phone calls. If you get a digital voice recording when you call the office, please try to navigate through to my voicemail, leave me a message, and I'll call you back. But I am happy to talk to you about it. All right, moving on AB 3088. I don't know how much time I have left, but I imagine it's closing in. Tenants are going to receive additional protections. And just when you thought they had already received all of the protections that and more that they should have received, and that the entire burden was being carried on the landlord's back, and you'd be right, they're about to receive additional protections. So let's go through those real quick. I've already told you they don't have to pay the 25% until June 30th. Their landlords are not allowed to implement any late fees or other surcharges on any unpaid amount. You're not allowed to apply. There is a civil code that states that when a tenant makes a payment of rent, a landlord is allowed to apply it to the oldest outstanding balance, which would bring unpaid balances forward. Under AB 3088's extension, landlords are no longer allowed to do that. They have to apply it to the month in which it was received. Landlords may not sell or assign any COVID debt prior to June 30th, 2021 at the earliest. There's some caveats to that one. And landlords, management companies, and tenant screening companies may neither report unpaid COVID rent as delinquent nor deny tenancy based on the fact that the tenants failed to pay rent during the COVID period. So the tenant just got a whole basket full of additional protections. Landlords are not allowed to file any lawsuits seeking unpaid COVID rent prior to July 1st, 2021. Of course, there's the caveat, unless the tenant fails to comply with their obligations under AB 3088. In other words, if you serve a notice, the tenant has to return to you that 15-day declaration within the 15-day period. If the tenant fails to do that, then you would be able to file an eviction. Now, there's some caveats to that too. Most people don't talk about those caveats, but I want to go through them so everybody has a clear understanding the way that would work. Under the original AB 3088 and under the extended model of 3088, if you filed or served a 15-day notice to pay rent or quit, and the tenant fails to return the declaration to you within the 15-day period, you would have the right to file the lawsuit right then and there. And in some cases, you may want to. Certainly, it opens the door to negotiation once they get served. In fact, I can tell you in the last 2 weeks, I've settled 4 or 5 eviction lawsuits because we went ahead and filed the lawsuit, and the tenant thought we couldn't. When they realized that we could, it brought them to the table, and we were able to negotiate a settlement. But there is a procedural component in the law that states if you file that eviction because the tenant failed to file a declaration within the 15-day period, but then the tenant goes to court and files that declaration with the court, The way the law is written in the amended AB 3088 is that the court shall dismiss your lawsuit without prejudice, meaning you could bring it again. You could bring it as early as next month when you serve a notice again. But if the tenant files that declaration with the court, the court shall dismiss that lawsuit if it finds certain things. Now, that's judge discretion. The court has to find mistake, inadvertence, excusable neglect, or surprise. In other words, the tenant was surprised. They didn't know they were supposed to do it. They were mistaken. They thought they had until June 30th. It was excusable neglect. I had an appointment. I was looking for a job in another county, and I couldn't get it back within the 15-day period. Any of those would give the judge the right to dismiss the case. But I will tell you, there are judges out there that would say, I don't find that to be a mistake. I don't find that to be excusable neglect. I'm not going to dismiss. So it's somewhat a crapshoot. Unless you know the specific judge you're going to get, it's hard to make a decision whether you want to file that eviction or not. But I'm just giving you the heads up. If you did file it because they failed to file the declaration, and then they went and filed it with the court could dismiss your case. So that's an additional protection that they received. And any civil action you might have against, this is another protection they have, by the way, any civil action you might already have filed in which you're seeking unpaid COVID rent will be continued. So let's say you filed a small claims action last month because the tenant didn't comply, and let's say the tenant moved out and they're no longer entitled to the Protecting Tenants with COVID Act because they're no longer your tenant. You went ahead and filed your small claims action. All of those cases that were filed based on unpaid COVID rent are going to be continued to July 1st of 2021, unless you filed it prior to October of 2020. So there's a caveat to that. All right, there's also new notice requirements for landlords. In addition to serving the notice requirements you have to serve under the original AB 3088, there's a new notice you're going to have to serve. That's going to be due by February 28th. As I've said in many other webinars I've done in the past several months, this is not a time for do-it-yourselfers in the landlord-tenant industry. We will have the notice for you, and we will have it drafted correctly, and we will have it served for you by a registered process server. So please don't try to navigate this environment by yourself right now. Whether you use us or your other favorite landlord-tenant attorney, please use an attorney for all of this stuff right now. Let's talk about the new notice requirements. Let me just make sure. Oh, yeah, you guys are going to love this one. A new protection for the tenant. Landlords, when filing any action for unpaid COVID rent now, are going to have to file with their complaint evidence that they made a good faith effort to assist the tenant with receiving rental assistance by either investigating whether the tenant qualified for governmental aid, seeking governmental assistance on behalf of the tenant, or cooperating with the tenant's effort to obtain rental assistance. Now, if you think you misheard me, you probably didn't. When you file any action now seeking unpaid COVID rent, you are going to have to attach a document that states you tried in good faith to assist the tenant with gaining tenant assistance. And if you don't file that document, or you didn't engage in good faith efforts to help the tenant, there are several penalties that could be put into place. One, for example, would be that any award that you got would be reduced by some amount. We don't know the amount right now, but the judge would actually have the discretion to reduce the amount he or she awards to the landlord, because the landlord didn't either accept the funds that are coming from the new program, or they didn't investigate whether the tenant was eligible to receive the funds, or they didn't assist the tenant with receiving the funds, or they didn't cooperate with the agency that was providing the funds. So why is this coming about? Well, because many of you received these letters over the last 10 months. Many of the city and county programs that were designed to help tenants with their unpaid rent required the landlord to sign a document that gave away the landlord's right to increase rents for 12 months and their right to evict the tenant for any reason for 12 months. And most of the landlords wisely chose not to give up those rights and said, forget it, I'm not going to take the money. It's not worth taking the money to give up those rights. And so the tenants' rights organizations went back to Sacramento and said, hey, look, we're trying to assist the tenants, and the landlords aren't playing ball. And so a couple things happened out of that. all of a sudden several programs shifted gears and said, well, then if the landlord won't cooperate, we'll just qualify the tenant and we will give the tenant the money directly to pay the landlord. Well, you can imagine what happened with that. Many of my clients called me up and said, well, we know they got the money, but they never gave us a penny. So the tenants now are receiving those benefits and not giving the landlord money. So it's kind of a damned if you do, damned if you don't situation. But the point is that that was the genesis of this requirement now that the landlords actually step up and engage with the tenant and investigate and try to obtain assistance. And this is what I'm about to tell you is the most egregious part of this whole thing. You see down on the bottom of that slide there, it says there's $2.6 billion in conditional rental assistance. What does that mean? Well, this law, the amended law, is going to provide up to 80% of the unpaid rent to the landlord. What's the caveat though? The caveat is that the landlord is going to have to forgive or waive the balance of that 20%. So some of my clients, that's a big number, and that will represent a huge number when you look at their entire portfolio. But if they don't waive the 20%, they don't have to, but there are punitive problems with refusal to waive the 20%. I just mentioned one. If you go after the tenant in the future in a breach of contract action, the judge will have the right to reduce their rental, the judgment amount. Right now, it's currently unknown how much they'll have the right to reduce it, but I would imagine it's going to be somewhere in the neighborhood of that 20%. I just want to make sure I'm not missing anything. Oh, and that's the other thing. If you refuse to waive the 20%, as a landlord, you will not be able to participate in the rental assistance program. So you'll be stuck with receiving only the 25% on or before June 30th of 2021. And you could have any judgment that you might get in the future reduced by some unknown amount right now. So the bottom line is that the landlord is now going to be saddled with additional notice requirements, additional responsibilities, and basically pushed into a corner where they either are going to walk away from 20% of what is owed, or if they choose to stick to their guns, they will be penalized by not being able to participate and receive any funds except that 25%, or having their judgments reduced in the future. So keep that in mind. That for the time being, that brings us to the end of this amended AB 3088 and to the end of the new laws session. I say for the time being because, as I mentioned several times now, AB 3088 is still being negotiated as I do this webinar right now. I anticipate it'll be voted on today. I may be wrong about that. It could be voted on tomorrow, depending on how heated the negotiations get. I wouldn't spend a ton of time looking up the bill or relying on anything I've said, because as we saw when AB 3088 initially went into law, it kind of came out of nowhere, and all this energy we were putting into other laws went up in smoke as soon as AB 3088 came out, and we had just a couple of days to digest it. So the point I'm making is tomorrow's Friday. Everybody just sit tight for a day or so. You know the bullet points of it now. The final version is going to come out by end of business tomorrow, and I'm sure it'll be distributed by all of the apartment associations. AOA's already distributed the bullet points of this version of it, yesterday, I believe. So we will be on top of it, and you will know by Monday. If you watch your emails, you'll know by Monday exactly what the amended version of AB 3088 is going to look at. So that's all I've got for the webinar. I think we're going to go into a question and answer session right now. And normally I create unlimited time for that. But today with my schedule, I am going to be a little bit limited. So Jeff, can you hear me?
Yes, I can.
Okay.
Can you hear me?
I can hear you very well. Thank you.
Excellent. What time are you able to go to today, Mike?
Well, I've probably got 20 to 30 minutes to spare.
Okay, great. Well, thank you for all of that. And yeah, I'll just go ahead. There's obviously tons of questions here. And I think it's important to know that things may change. Like what you say today may be different on Monday. That's what you've just told us, correct?
Correct, yeah.
Right.
I think you have the highlights. I think the substantive provisions probably won't change much. But like I said, I wouldn't count on anything right now because anything can happen between now and Monday.
Great. And if you're not signed up for the AOA e-newsletter, you sign up for that, you would have gotten the last one, and we'll be sending out more information as things come up. And Mike's website is great as well. And we have in the contractors and vendors in the AOAUSA.com. If you go there, there's a bunch of attorneys that you can look up. So there's all sorts of ways to do it. I really like Mike. I like everything that you do. I like the way you run your operation. And it's just an honor to have you on. So we'll go ahead and start with some questions. Okay, I have a tenant whose lease expires on February 6th, and she wants to move out on February 28th. If she does not move, can I still evict her? She has a full-time job and only pays half of the monthly rent.
So that's a fantastic question. I get it a lot. Here's the challenge we're about to enter into answering any of these questions right now. The very first question that I always going to have to ask everybody is, where is the property located? So there's, for any question that pops up, there's this cumbersome analysis you have to go through. The first question is, where's your property located? Because that determines what, if any, eviction moratorium you're under. So for example, if that property is located in the city of Los Angeles, no, you're not going to be able to evict that tenant. But if it's located in a jurisdiction that has no moratorium, then that person would be under AB 3088. And I would wait till Monday to make a determination, because that'll be the extension of AB 3088. But what I said before about filing evictions and bringing people to the table, it still applies. If you have a good faith basis, like for example, in this case, the woman's lease expires. Under normal circumstances, pre-COVID, the tenant would be what we call an illegal holdover. That's a basis to file an eviction. The problem with a lot of people is they don't want to file the eviction. They're concerned about the laws, and I understand that completely. Or they don't want to spend the $1,000. So they come into this agreement with the tenant and they say, okay, I'm going to let you stay till February 28th. Problem is that on February 28th or March 1st, the tenant didn't find a place to leave. You have no eviction in the pipeline. You have no hammer over the tenant's head, and you're stuck now, and the tenant hasn't paid you rent, and the tenant's sitting there telling you, I have nowhere to go. I can't leave, COVID. I can't go out, this, that, and this. So again, depending on a lot of factors, cumbersome analysis, I say, I don't know if you can file that eviction or not. It'll depend on where that property is located. If you want to talk about that, then again, call the office. We can work through the analysis. But assuming you can file an eviction on February 6th because she's an illegal holdover, my recommendation would be go ahead and do it, because you can always enter into an agreement with that tenant to vacate on the 28th. And that agreement could say the record's going to remain sealed. We'll dismiss this case. Maybe the landlord even kicks in some concession and says, I'll waive the rent for February if you do in fact leave on time. But if you don't leave, and here's the hammer, if you don't leave, we're going to just go right to a lockout. We're not going to have a trial. As long as you do what you say you're going to do, this whole thing goes away. But if you don't do what you say you're going to do, then I have the right to go right to a lockout. That's the benefit of having the eviction and having the stipulation on hand.
Hey, Mike, you're still in presentation mode. Could you stop sharing your screen?
Yes, absolutely.
There we are. Okay, great.
Sorry about that.
Everybody can see your beautiful face. There we go. All right. Thank you.
You're very kind with your words. I don't know if I'd call it beautiful, but certainly smiling.
Yes. Yeah. Thank you. Did you want to say any more on that? I kind of cut you off a little bit, but
that's okay. I said what I had to say.
Yeah. Okay.
The overview is that everybody who's going to ask a question today, it's always going to depend on where your property is, and it's going to be a multi-step analysis. So I apologize in advance if some of you walk away going, he didn't really answer my question. Very difficult in this setting.
Great. And on YouTube, we have Jane, and she's just asking, where is the landlord going to apply for that assistance?
So the state is currently putting together an administrative process for that. And there are terms and phrases that I've never had to know what they meant before in my life, such as a block grant, and they're using populations to determine how it's going to be handled. For example, LA has a huge population, so that's going to be handled one way, whereas San Bernardino has a much smaller population, so that may be handled a different way. right now it's in the works. It hasn't been fully fleshed out in the law, but it will be. Larger jurisdictions like Los Angeles are going to assign a specific person through one of the housing. It might even be a private housing agency, but they will assign a certain person to start administering those funds through the housing departments. And it will, like I said, depending on the population of the jurisdiction, it may be handled differently. I guarantee you, you will know very soon. As soon as those agencies are up and running, you'll know. And I can only tell people who were dealing with the PPP loan at the beginning of COVID, they'll understand what I mean. PPP was announced right away, but it took a couple months of insanity before people started to receive the funds because the administrative or the infrastructure was not there yet. And I anticipate the exact same situation happening now.
Right. Okay. Here's Charlie. We have an eviction in process. Today is default day. Does the moratorium pertain to us at this stage, or will we be able to go forward with the next phase of the eviction?
So that's a great question because we have a lot of cases with defaults right now, and we have a lot of cases with judgments. What I'm finding is it depends on the court. Believe it or not, you would think there'd be these uniform policies in place. Many judges are sitting on defaults. I'm going to ask you to excuse me for a second. I'm going to close my window. Thank you. Sorry about that. Many judges are right now. The law changed under the original AB 3088. It used to be that if you had a default, a clerk could actually enter a default judgment for possession of the property. That changed. Now a judge has to sign off on those defaults. Some judges are signing them. We're getting them through, no problem. Other judges are sitting on them. And when we come to the supervisor and we say, hey, what's going on? The judges are supposed to be signing these. The supervisor says, my hands are tied. I can't do anything. So recently we started, not too recently, but relatively recently, we started filing ex partes to have the judges come through and sign these default judgments. Some of them have. Now, what I anticipate, being a cynic, especially because most of my cases are in LA County, I anticipate that the judges all know that this extension is coming out, and they are going to continue to sit on these defaults for the next few days, and they want to read through these laws and see how this impacts them. Now, the law specifically does, at least it alludes to or implies that existing eviction cases are not going to be touched. So they should be able to move through as usual. But I wouldn't count on that just because of the discretion that is given to these judges and what we're seeing play out, which, like I said, the judges are delaying things.
All right, here's John Silver. Tenants have been declaring COVID hardship starting September 1st, at the beginning of the transition period. They have not paid the 25%. Does the new law cover them? Or can I start an eviction process on February 1st? So
the new law, that is why. So another great question. As you know, the current AB 3088 expires January 31st. The new law is the way it's written, is set to kick in February 1st. So is there any overlap there? Yes. And the reason there will be overlap is because when this law is signed, either today or tomorrow, or possibly over the weekend, but I doubt it, it's being pushed through as what they call an urgency measure. And so it will go into effect immediately upon signature. So that will extend that January 31st date through June 30th of 2021. And it'll extend all the protections. So for those tenants who didn't pay the 25%, and those landlords, I should say, who didn't receive the 25%, you're going to get pushed to the back of the line again. That's why I said it's such a shame. You guys are going to go another 5 months without the tenant having to pay you a penny.
Right. So there's really no way to get them out. You're just going to have to wait all the way to the end of June.
I wouldn't say there's no way to get them out. I would say that if you're trying to get them out for unpaid COVID rent, your hands are really being tied behind you. And so, there are ways we're still filing evictions. Obviously, I don't want to go into detail on the internet about things like that, but mainly because I know that the tenants' rights groups watch these videos as well. And then they go back and they say, hey, look what these greedy bastard landlord attorneys are doing. But there are other ways. They're challenging. They're not easy. They're not cheap. But, really the laws are written. Again, it depends on where your property's at, what moratorium you're dealing with. As far as the AB 3088, that's really just dealing with residential tenants on non-payment of rent issues. So there are other avenues that you can seek, but I will caution your members, if you decide to seek another avenue other than unpaid rent, be aware of the fact that even the original AB 3088 and the amended version, they beefed up what is called the retaliation civil code. And it has specific language in there that says, I'm paraphrasing it, but it says, if you're evicting on somebody other than non-payment of rent, so let's say you're claiming they breached the lease, but it's really a pretext and you're really evicting them because they didn't pay COVID rent, then the tenant has the right to raise that as an affirmative defense. And if they can prove that that's really why you're evicting them, then you're going to lose that case and there could be some additional penalties. So don't, like I said, this is not the do-it-yourself world we had, a couple years ago. Don't try to navigate through this stuff on your own. Call an attorney and get the analysis and walk through it and understand your risks before you do anything.
All right, here's Ming Chen. It's slightly different. The lease ends on January 31st, and she's already sent a 60-day notice for the tenants to move out. So in that case, what would happen?
Who sent the 60-day notice, the tenant or the landlord?
The landlord.
Well, again, I can't tell you what would happen. Every single one of these questions, it's going to depend on the jurisdiction in which the property is located. What I can tell you is if it's LA City, nothing happens. You're not going to be able to file that eviction. And if you did, you could be exposed to penalties, a private right of action. If it's LA County, whose moratorium is expired, but they're claiming it's not expired, and they have a private right of action and penalties as well, then you have a better shot of filing that eviction. But then you're going to have to look at, does AB 3088 cover this situation? So there's so many questions. I wish that the city and the state had not done such a hodgepodge job of these moratoriums, and they would have given us one uniform law. But unfortunately, they didn't, and it really prevents me from answering with concrete answers. But call your attorney and walk through the analysis with your attorney to figure out what you can and can't do. But don't try to make decisions on your own because of these private rights of action.
Right. Here's an interesting question. Andrew Chan, he's asking about, what about the relocation fee? If a tenant agreed to a relocation fee, would you go that route if you were in his shoes?
So it sounds like, I'm speculating a bit here. It sounds like Andrew is talking about what we in the industry would commonly call the voluntary vacate agreement, where you're going to pay the tenant to leave. Those are completely enforceable if your local moratorium doesn't prohibit them. And what I would say to anybody who's considering that is, first, read your local moratorium, make sure it doesn't prohibit that. Off the top of my head, I can't think of any that prohibit it outright. But what I can tell you is there are moratoriums that have certain requirements for it. And on top of that, certain jurisdictions, for example, the city of Los Angeles, if you want to do a voluntary vacate buyout agreement with a tenant, under the RSO, the rent stabilization ordinance, there's very specific requirements that have to be met. And if they're not met, it gives the tenant a right of action against the landlord to sue that landlord, even after the tenant moved out and took the money. So make sure that if you want, the voluntary vacate agreements in general are a valid contract. But before you go down that path, especially before you give any money away, make sure you read your local ordinance and it's not prohibiting them. Then make sure there's no local rent control ordinance in place that might have specific requirements. In other words, again, go talk to an attorney that does nothing but landlord tenant for a living.
Right. And next week we have Richard Beckman, who's going to be on. He's in Northern California. And this question was specific to San Jose. So Richard Beckman probably would be a good one to answer that on the local level for Mr. Chan there. And All right. Next question. Okay. When a tenant finally does move out after not paying rent during COVID, can we use their security deposit towards back rent?
Well, that's a great question. For right now, my analysis of this, and I guess I should, here's a great place to give a disclaimer. There's no landlord-tenant relationship here. I'm not giving anybody legal advice. I'm simply doing a webinar to millions of people out there in the world. My interpretation of the laws as they currently stand are that when a tenant moves out, they are no longer subject to the protections of AB 3088 as far as I'm concerned. Meaning if I'm the landlord and they vacate on me and they owe me all this rent, they're not subject to AB 3088 anymore. Now, having said that, because of the new law, the new portions of the law that I just read before that said you can't use the security deposit for unpaid COVID rent, that's a new section. I'm going to caution this landlord if that happens, wait a couple weeks, a week to 2 weeks before you do anything, because several attorneys out there, including myself, are going to unpack this law in greater detail and come to a conclusion, because I certainly anticipate that coming up a lot. But if they, one thing I can tell you for sure is it will depend on when the rent, what period of rent you're trying to apply it to. Certainly, if it was a pre-COVID rent that they owed you, then absolutely, you can use it. And the security deposit law, like I said, hasn't changed. It says you can use it for unpaid rent. The only caveat is that it now appears to say that you can't use it for COVID rent, which the definition of COVID rent right now is March 1st of 2020 to June 30th of 2021. So like I said, wait until we've all had a chance to really thoroughly digest this law and figure out what you can and can't do. And like I said, anybody who wants to get on my mailing list, because I put newsletters out on specific issues within these laws all the time. If you want to get on the mailing list, call my office and just tell a staff member, hey, I just saw Mike on the AOA webinar. I want to get on the mailing list. Give them your email address and they will put you on the mailing list. And I'm also going to provide you with an email address right now, but it's a bit long. It's rental.property.news with an S at mbrennanlaw.com. So I'm going to say it again and I'll spell it. rental.property.news with an S at mbrennanlaw.com. mbrennanlaw is spelled M like Michael, BRENNANLAW.com. You can send a request to be added to the newsletter to that, and I will get you on the newsletter. And as I unpack this thing and figure out what it looks like it's saying, I'll send out the bulletins that says, hey, this portion says this is how we're interpreting this.
Right. And thank you. We definitely, even in our office, we call you all the time. And we're just very grateful. You're a tremendous resource, even for our advisors, is when people call in for help. So thank you so much.
You're very welcome.
And we just got maybe just a couple more questions, and we'll honor your time as you requested there. Let's see.
That's funny. You guys sent me through the chat. You sent me a request to stop sharing my screen.
Yeah, you
can see how on top of this stuff I am when I'm talking.
Yeah, well, you're focused. That's good. I need to get documentation from a tenant who I believe doesn't qualify for TPA and therefore filled out an application fraudulently. Can I evict it if I can prove that they filled that out fraudulently?
Okay, that is a great question. The only way that off the top of my head, the only way I would tell you you'd be able to do that right now would be, let me back up for a second and give you another component of AB 3088. AB 3088 has a specific portion called high income tenants, and it allows different procedures for those tenants who make us above a certain amount. I'm paraphrasing right now, but essentially it's $100,000 or more. or above a certain percentage of the mean in a specific location, they're considered high income tenants. And for high income tenants, you are allowed to ask them for a different level of documentation. In fact, you're allowed to ask them for documentation to prove that they've been impacted. However, it's got some caveats, and those caveats are, in order to fit them into that category as a high income tenant, you had to have the information about their income level prior to COVID hitting. So it's not something you could have come up with right now. And so the way the question was phrased, very simply, I don't know if your tenant is a high income tenant. I don't know if you had that information prior to that. There are certainly downsides to being wrong. If you file an eviction and you want to prove that they're filling this out fraudulently, many of these moratoriums and the laws actually create what's called a private right of action against a landlord who violates this moratorium. And these, even if your lease has a cap on attorney's fees, many of these moratoriums have this private right of action that awards actual damages, punitive damages, attorney's fees. That can be a very, very costly lawsuit for a landlord. And in this environment where people like myself who do this day in and day out, every single day, have to read the law every single day because it's so convoluted to try to figure it out, I would be very cautious about trying to evict somebody or filing a lawsuit right now based on an allegation that they're committing fraud. Most of the moratoriums and AB 3088 do not require any documentation other than some random generic declaration that says, hey, I was impacted. So you are opening the door to potential liability depending on where your property's at and what the local moratorium says. So again, I'd be very cautious before I just decided to do that.
Great. And yeah, there's so many questions. I'm sorry, guys.
You can keep going. I've got a few more minutes. I'll go.
We won't get to it because there's just so many. But I'll ask this next one. How can I prove a tenant is a nuisance and be sure I won't be accused of retaliation?
Great question. So nuisance, anybody who's come to any of my seminars over the last, whatever I've been practicing, 12, 13 years, one of my key phrases is document, document, document. Nuisance has about 3 or 4 different descriptions or definitions under the California laws. And so one of those definitions is very vague and very broad. It states anything that's offensive to the senses. Well, what the heck does that mean? If the guy next door to me is playing his stereo loud, is that offensive to my senses? Maybe. If he's playing it loud at 3 o'clock in the afternoon, the judge is not going to be inclined to deem that a nuisance. If he's playing it every morning at 3 o'clock in the morning, loud so the whole apartment can hear it, I don't know a judge who wouldn't call that a nuisance. Mm-hmm. So the point is you've got to prove it. You've got to document. If you've got a legitimate nuisance or a legitimate breach of contract, do your best to document it right now, because it's going to be a very rare judge that looks at just a significant amount of evidence that proves a nuisance or proves another breach of the contract and says, oh, I think you're making this up. I think this is a pretext. You're really just doing this because you're retaliating because they owe you rent. That's not going to happen. Now, what can you use to document it? If it's loud noises, you're going to have to get a recording advice. If it's behavior, you're going to have to get a video camera. I encourage all of your members, install, video cameras in random places around your property. Talk to a video guy. They'll tell you exactly how to set them up. I've got an active case right now. My client is probably listening to this right now. I have an active case where we're evicting somebody because he's a major nuisance, including smoking methamphetamine in the parking lot where he dropped his meth pipe, and the manager picked the pipe up. So we happen to have a lot of documentation on that. So, and he's been arrested for felony warrants on the property. We have pictures of the sheriff and video of the sheriff arresting him and taking him away. So I wouldn't worry so much about a claim of retaliation if it's a legitimate nuisance case. I would just document it every single way I can. Look for witnesses. If you have neighboring tenants that are complaining to you, ask your tenants to put the complaints in writing to an email. Once you have a written complaint, here's what typically happens. A tenant comes to you and says, you need to evict this guy. He's a nuisance. Okay, great. Will you come to court and testify about that? You're darn right I'll come to court. Absolutely. You evict that guy. Then a week before trial, when we're calling them saying, hey, remember when you told us you'd come to court? Oh, I'm not coming to court. No way. I'm going to be out of town that day. No, I have to work that day. My boss said no, because it dawns on them the last second. Hey, if they lose this case, I'm stuck with this numbskull that I just testified against. My tires are going to be slashed. My car is going to be scratched. My windows are going to be broken. So, but if they put it in writing, either way, whether they put it in writing or not, I have a writing that I can use as evidence. And I know people are going to scream hearsay. There's ways around hearsay. But on top of that, I can subpoena that person to court. Right now, they have to come, not because they want to, because the court's ordering them to. And I'm going to show them that email and say, didn't you write this? Isn't this your email? So the point is, document. Build a case against your tenants long before you serve any notice. And what I encourage people to do, and again, this isn't cheap, it's not free, call your attorney and lay out a strategy in advance. So the attorney can walk you through, hey, if this is what the tenant's doing, this is what we're going to need to do to win your case, or at least to come close to winning, because obviously attorneys aren't allowed to guarantee anything according to state bar rules. But the point is, talk to an attorney who understands the rules of evidence, understands the civil code, understands the code of civil procedure, understands the hoops that are going to need to be jumped through to have better odds of succeeding. But don't try to do it on your own. And even if you are trying to do it on your own, document it every possible way. Police reports. You can call the police and actually get reports of all the incidents to which they responded at your property, and they'll break them out by unit number. So there's a lot of different ways you can go about it. If you really have a nuisance tenant, do yourself a favor, get rid of them now so that you don't lose your good tenants.
Absolutely. Great. We'll just ask one more question because it was asked multiple times. And
Okay.
It's the question whether AB 3088 applies to commercial tenants.
No, it does not.
Okay.
Neither the original nor the amended version applies to commercial tenants. I will caution whoever asked that question, go look up your local moratorium if there is one, because many of those do, like the city and county of LA, those both apply to commercial. Santa Monica applies to commercial. So there are plenty of jurisdictions out there where it does apply to commercial. AB 3088 is limited strictly to residential units.
Great. Yeah, there were so many bombshell things that these other things that you shared that really deserve attention, and we're just really completely out of time. One of my taglines is, what you don't know may cost you a fortune.
Oh, yeah.
And so I want to encourage everybody, see an attorney, don't do it wrong. But that's really the tagline we use for AOA too, because we want to keep you informed so that you don't really get yourself in big trouble. And
it's a landmine out there. I mean, you're walking through a minefield right now. Right. And even when COVID's over, here's one thing I'm going to leave you guys with a parting shot. Thanks. I alluded to this before. Even when COVID is over, what I'm seeing coming out of Sacramento, they're just on like hiatus right now. The attack on landlords' rights, we've discussed this. Your dad and I have discussed this many, many times. The attack on private property rights coming out of Sacramento this is just the beginning. It pays to stay informed. For all your members who are members and actually come to the educational courses, there's no better move you could be making for your business than to be attending those educational courses, receiving the web emails, the newsletters, all that stuff. AOA provides just amazing bang for the buck. For the cost you pay, the information that comes out of you guys is fantastic. But I encourage you, if you do have legal issues or questions, don't leave it there. Reach out to your attorney and get your questions answered before you make any moves.
Thanks, Mike, so much. Really appreciate you. Next week, just again, want to remind everybody, next week we have Richard Beckman from Northern California. He's not going to be able to answer Southern California questions that are low. He's not going to be able to do anything with that. He'll probably be able to share more about 3088 and in a more general way, and then also specifically for people up in Northern California, because we have members all throughout the state. So go ahead, hit the subscribe button, sign up for our newsletter, sign up for Michael Brennan's newsletter. These are free things. These are free resources. There's no reason not to. And we appreciate you for providing housing. And remember what Dan Fowler said at the very beginning: get out that pen and paper and write. You have to write regular snail mail. That's what these guys need to see. We need to flood it. So flood everybody from the governor down to the local level. You got to just hit it all. Spend some money on stamps. Just go get a roll, and
Jeff,
we got to do it. What's that?
Can I add to that?
Please.
Not only do you want to write letters and use snail mail, write checks. Write checks to PACs, to all these organizations that fight it. Write checks to AOA. Donate $25 a unit, whatever it is. Donate to the organizations that are out there fighting against these anti-private property laws. That's all I wanted to add.
Right. And, we get a lot of calls all the time. Hey, well, what's AOA doing about this? And we're here to empower you. We're here to help you get your voice heard. And so here's the issue. Get that snail mail in the mail, and you'll be in. When you do that, then we have power. So it's really about a grassroots effort. Thanks again, everybody. We'll catch you next week.
Thank you, Jeff.
Thanks again, Mike. Appreciate it.
You're welcome. See you guys.